My topic this morning is on post-termination bonuses, and for the regulars who have come, you'll know that we did do a bonus topic in 2017. So this is a bit of an update to that subject because things have changed a little bit over the past year. As everyone knows, when employees are terminated without cause, they are entitled to notice or pay in lieu of that notice. And typically that pay includes all of the compensation, so wages, benefits, etc. Bonuses are the one topic that tend to cause a lot of issues, and there tends to be a bunch of case law about bonuses arising post-termination, particularly where there is no actual working notice given and the employee is given pay in lieu of that notice. There are often issues related to actively employed language that tends to show up in bonus plans, and bonuses are often argued to be discretionary. And so many of the issues relate to those topics. In 2016, the Court of Appeal gave us some direction in a case called Paquette and Terrigo Networks. We talked about this case in 2017, but Mr. Paquette worked for Terrigo for 14 years until he was dismissed. He was awarded 17 months of pay in lieu of notice under common law based on the typical Bartle factors of age, etc. And the trial judge in that case refused to award Mr. Paquette any bonuses that he would have received during the 17-month notice period. The trial judge based that on the fact that the bonus plan in Mr. Paquette's case required him to be actively employed on the date of the bonus payout. And of course, because of the termination, he was not. Mr. Paquette was not happy with that decision, and so he appealed to the Court of Appeal. The appeal was allowed, and the Court of Appeal overturned the trial judge's decision on the bonus issue, and Mr. Paquette was awarded damages equal to the bonuses he would have earned during the 17-month notice period following his termination, even though he didn't work a day of those 17 months and didn't really contribute at all to the profits, etc., during that 17-month time frame. And the Court of Appeal essentially held that where a bonus is an integral part of an employee's compensation package, the employee is entitled to that bonus had they, in fact, worked out their notice period. And the case has been cited a number of times since then for this proposition that essentially damages awards should place the employee in the same financial position that he or she would have been in had the notice been given. And that relates back to an old Supreme Court of Canada decision in Sylvester. And so in Mr. Paquette's case, taking a closer look at it, even though in this case the bonuses were phrased as discretionary, the court held that it was an integral part of his compensation, and that's in part because his bonus history looked a little bit like this. So in 2011 he had a $27,000 bonus, 2012 $31,000, 2013 $27,000, and 2014 $7,000. So he had gotten a bonus every single year for the 4 years leading up, and they were not insignificant bonuses. Employees who lose out on that amount of compensation are likely going to argue that that is an integral part of their earnings. The court also in that case made it clear that you do need to look closely at bonus plans, though, and the language in the bonus plans to figure out whether or not there is eligibility criteria, as well as how to calculate the bonuses, etc. Now, in Mr. Paquette's case, the bonus, as we said, the bonus plan provided that an employee must be actively employed by Terrigo on the date of the bonus payout. But the court held that this provision didn't assist the employer, and it didn't preclude the bonus from being payable, essentially because the court held that really the employer could have given working notice to Mr. Paquette, and had he been given working notice, he would have worked for that 17-month time frame, and he therefore would have been entitled to the bonuses. And so in these sorts of cases, the court has held that it's really damages for bonuses that they could have earned had they been given the adequate notice period or had they been given working notice to earn that. Now, at the time this case came out, and in the earlier seminar that we did, There was some concern about whether or not the subsequent courts would follow this decision. The language does say actively, which, in my mind certainly suggests that you're actively actually there. And so the court did seem to ignore that particular word and render the decision that it did. I can tell you, though, that the case has been followed many times since 2017 by some lower courts. And they have really grabbed onto that language that I suggested, that it's really a damages calculation as opposed to anything else. Now, a case from 2017 that was a lower court decision back in 2017, but has subsequently been confirmed by the Court of Appeal, is a case called Kiel versus National Money Mark. And this is a good case to give us an example of what kind of a bonus plan language will the court listen to, as opposed to in Paquette, where they kind of ignored the actively employed portion of it. And I just put the provision up here on the slide, and so you'll have it in your materials. But there can be no doubt on the reading of this bonus plan provision that those bonuses are not payable for the notice period. And again, I won't go into it, but this is a really good example. If you want to be super clear about the fact that the bonuses are not going to be paid, this is a perfect example of how to set it out in a bonus plan. So the Court of Appeal has confirmed that in that case the bonuses were not payable, so that's the language you want to try and adopt in some of your employment agreements if you're going to try and preclude that sort of thing. Now, we also have had a case come down from the Court of Appeal last year, which also helps us to figure out the law in this particular area. And we had a case called Singer and Nordstrom Equipment in 2018. So Mr. Singer was a president and general manager of a company that makes bulk moving equipment and things like that. He was 53 years old, and he had earned $180,000 base salary plus bonuses annually. He was terminated in the middle of December in 2016. And he sued and then subsequently brought a motion for summary judgment. The bonuses that Mr. Singer had earned were even more significant than the bonuses that Mr. Paquette had been earning. So he had been earning bonuses anywhere from $56,000 a year to up to $120,000 in some years. And his bonus calculation was based on a profit pool for his particular company's division, and the bonuses that Mr. Singer earned as a percentage of those bonus pools was set out. Now, Mr. Singer had argued that he was entitled to a 5% bonus. Based on these numbers, you can see the court held ultimately that no, that wasn't really the arrangement, that in fact his bonuses were very variable throughout the years. But the trial judge did provide Mr. Singer with 17 months of notice, so the same as Mr. Paquette by coincidence. And the court in that particular case held that certainly for 2016, Mr. Singer had worked almost the entire year, and with his statutory notice periods added on, he would have worked the entirety of 2016. And so the court held that the 2016 bonus was integral, and it was certainly not discretionary. And they provided him with 4.6% of the profits in 2016 from the bonus pool, which is an average of those numbers that he had earned in the previous years. The employer had tried to argue that it had discovered in 2016 that Mr. Singer was not a good manager. The court rejected this argument because the termination letter made no reference to that at all. The employer also argued that the bonus was discretionary, and that in fact the division wasn't particularly profitable in 2016 and was underperforming. And so Mr. Singer ought not to be entitled to a bonus based on their discretion. The court again rejected the argument and said that the bonus documents were very clear that bonuses were awarded out of the profit pool, and so if there was a profit pool, there ought to be bonuses. And even though the historical amounts that had been paid were variable, they weren't really discretionary. They were essentially required. And in this case, again, the employment letter made no reference to the ineligibility for the 2016 bonus, so the court said, this isn't after the fact, and we're not going to give credence to it. The lower court, however, denied Mr. Singer bonuses for 2017 and 2018, which he would have been entitled to during his 17-month notice period. And effectively, the court did not follow the Paquette reasoning. The court said that really notice is provided to an employee to give them an opportunity to find alternative employment, not to earn bonuses, and that it was really not within Mr. Singer's reasonable expectation that he was going to get those bonuses during the 17-month notice period. Of course, both sides appealed, and the Court of Appeal upheld the 17-month notice period, and they also upheld the payment of the 2016 bonus payment. So the employer was shut out on its portion of the appeal. The Court of Appeal did reverse the lower court's decision in respect of the 2017 and 2018 bonuses, and provided Mr. Singer with the bonuses that he would have earned, and again adopted an averaging approach based on bonuses that he had earned in the 2 years prior. The Court of Appeal also restored his benefits, as a side note. The Court of Appeal essentially indicated that the lower court had erred by failing to follow Paquette, and it reiterated the two-part test from Paquette as being good law in determining whether these bonuses are payable or they are not. And so essentially the analysis is, again, number one, is the bonus integral part of the employee's compensation package? And number two, if so, is it precluded somehow by specific and express language in a bonus plan, and therefore not payable? So that's helpful in indicating where the law is going in this particular area, and clearly Paquette is now very good law, and Singer has reaffirmed that it is very good law. And even though companies use bonuses as sort of de facto incentives for working and performing, the court said in this particular case, employees don't have to be there, they don't have to be working, and it doesn't have to always be an incentivizing thing. In this particular case, it's damages that they're entitled to as a result of the decision to terminate, and as a result of the decision to terminate without providing working notice and providing pay in lieu of the working notice. Of course, any bonus agreements or plans that exist have to be made known to the employee, otherwise they're not going to be something that employers can rely upon. And that's long settled case law from previous decisions. So if there are bonus plans, make sure that they are known to the employees, make sure that they are part of the employment contract if possible, and make sure that they are updated and changed and circulated when they are, so that at all times employees are aware of the limitations and cannot argue that they were not. Quick takeaways. Bonus provisions that require an employee to be actively employed are not going to be sufficient, and you are going to need to adopt language more like the Kiel case law provision to make it abundantly clear that they are not payable in particular circumstances, if that's what employers would like. And where an employer elects to give working notice, elects not to give working notice, they need to be aware that they are going to have to pay benefits, including bonuses, during those notice periods in the event of a termination. And where bonuses are an integral part of the compensation and where they are not limited by bonus plans, they are going to be payable. So that's the law, and hopefully that helps. Up next, Nicholas is going to speak to you about amendments to the Employment Standards Act, Bill 1848 to Bill 47, courtesy of Mr. Doug Ford. So I'll leave it to Nicholas.